In the most practical, simple terms, what we know is this. We know that federal law enforcement authorities would have had to go to a judge and bring to that judge a request for a search warrant. In order to get a search warrant from the judge, the authorities would have had to tell the judge where they wanted to search and what they wanted to search for. And they would have had to demonstrate to the judge probable cause that at that location they wanted to search, they would find evidence that a crime was committed. A federal crime, a specific federal crime, which they would have to spell out in detail to the judge. The judge would have to be satisfied in the specificity of the request in terms of the location and what they were looking for, and in the assertion that there is probable cause to believe that evidence of a crime would be found at that location. If the judge was so satisfied, the judge would then agree to sign and authorize the warrant, which could then be executed by the FBI within 14 days. We know that just as a categorical matter in terms of what today's news implies about what's led to this point. Now, Kelly O'Donnell reports for NBC News tonight that after the warrant was obtained, but before it was served, the FBI notified the Secret Service today that they were going to come to Mar-a-Lago today, this morning, in order to execute this search warrant. Former President Trump himself tonight confirmed in an online statement that the raid had taken place. He noted in this statement that he felt aggrieved, I guess you'd call it, by the search. More interestingly, though, he also noted that the execution of the search warrant had included the FBI breaking into his safe. I mean, depending on the terms of the search warrant, one would expect that a search warrant of this nature might include everything to be found at the property, everything related to the potential crime that the authorities had to assert probable cause about. So therefore, breaking into a safe wouldn't be that much more serious and acted than the rest of the search itself, but he has volunteered. Quote, they even broke into my safe. So at least if we believe his word, we know that was part of it. I want to bring now into the conversation Chuck Rosenberg. He's a former U.S. attorney, former senior FBI official, and the person who I immediately get in touch with on nights like this to make sure that I've got the legal part of this at least under my belt, and I can explain it in a way that's going to make sense to other non-lawyers such as myself. Chuck, my friend, thank you for being with us tonight.
Well, thank you for having me, Rachel.
First, let me just get your top-line reaction to this raid. Tell me if I've said anything thus far that doesn't strike you as correct in terms of the way these procedures work. Tell me what you think about the seriousness of this.
So your explanation at the opening of your show was spot on. I'm not sure why you need me. I will say this. It's astonishing. Like, just step back for a moment and recognize that the Department of Justice went to a federal judge and got a search warrant for the home of a former president. I mean, putting aside what's in the affidavit, putting aside what crime they specified, putting all that aside, this is not something, and this is an understatement, that happens lightly at the United States Department of Justice. And then one thing I would add, you made this point, but I want to sort of amplify it, Rachel. Two branches of government are involved in a search warrant. The executive branch, the FBI and the Department of Justice, that asks permission, and the judicial branch, which grants permission. So this is not some FBI agent off by herself seeking to search a former president's home. Highly scrutinized. The most fly-specked affidavit, I suppose, in the history of the United States Department of Justice, and then approval by a federal judge.
Chuck, I started making calls and texting people as soon as the news broke tonight. And in addition to yourself, I spoke to another former very high-ranking DOJ official who told me a couple of things that I just wanted to run by you. And this is a person who's not comfortable being identified publicly, but was willing to let me characterize their remarks in terms of framing their understanding of what happened here. And the first comment I got from this person jibes a little bit with what you just said, that Attorney General Merrick Garland himself would have had to approve this personally. And the official I spoke with also pointed out that Attorney General Garland approving this as a search rather than as a subpoena may be significant in that it may mean that the Attorney General was convinced that these documents in question were at risk of being destroyed. Or were potentially at risk of being disseminated to third parties, which would further aggravate, worsen the crime here in terms of mishandling classified information. What do you think about that aspect of this?
It makes sense to me. First of all, Rachel, a subpoena and a search warrant aren't mutually exclusive. You could execute a search warrant and simultaneously hand the person a subpoena for the same records, meaning regardless of where they are, we want them back. And that we want them back piece is so important to my other point, to the question you just asked. We want them back means we want them back regardless of how we get them. And if we have to get a search warrant to get them back, then so be it. If you don't trust the person with a subpoena, because a subpoena simply says, hey, Rachel, here's a subpoena for your stuff. When you get around to it, or at least by the date that the grand jury is meeting, give us the stuff. There's indicia of trust, right? You may be under investigation, but we're allowing you to give it to us on your timetable. That doesn't happen in a search warrant. We need this stuff. We want this stuff. The fact that this stuff is out there can do grave damage to the national security of the United States. We're not just going to ask you for it. We're going to take it. And so that's a very big deal. So subpoenas and search warrants are not mutually exclusive, but a search warrant is the most serious way that the Department of Justice and the FBI can get back something that it needs or wants. And again, has to be authorized by a federal judge. It's a very big deal.
And Chuck, if the New York Times reporting is correct that this is about the classified documents, the alleged mishandling of classified documents reported by the Washington Post, reported as a grand jury matter by the New York Times back in May, if that is the basis for this search warrant, number one, if the search warrant turns up evidence of other crimes, what happens to that information? Is that also equally sort of in the possession and usable by the Justice Department? But also, is it unusual that for the specific crime of mishandling classified information, you would see a tactic as aggressive as a search warrant as opposed to just a subpoena? You would see a raid of this magnitude. You would see a former president not afforded, informal deference for less intrusive means. Mishandling classified information does get prosecuted, but does it get prosecuted in ways like this?
Yes, and yes. So mishandling classified information, retaining classified information, at its worst, transmitting classified information with the intent to harm the national security of the United States. All of those are felonies. All of those are crimes, some more serious than others. But if you don't trust someone to give you the stuff, then the way you get it back is through a search warrant. That's what's so astonishing here. The former president of the United States couldn't be trusted to return it, simply with a subpoena. And so to your earlier point, Merrick Garland, who had to be involved in this, it would be remarkable if he were not, had to sign off on a search warrant to go take the stuff. Listen, I handled very classified information, highly classified matters. Lots of stuff in the federal government are overclassified, but there are crown jewels. And if those crown jewels get out and in the wrong hands, they can do grave damage to the national security of the United States. And so if you don't trust someone to return it, Rachel, what do? You ask a federal judge for permission to go take it.
Chuck, if I mentioned that in the case of this former president, and it almost feels hyperbolic to say, but I mean it literally, when hearing about the raid by the FBI on his home, you don't automatically know which federal grand jury investigation it might pertain to, because he does appear to be potentially implicated in multiple investigations of multiple potential crimes, at least 3 of which are under separate federal grand jury investigations that have been reported in the press. Given the January 6th adjacent investigations, for example, if this search warrant was effectuated about the classified documents investigation, but it turned up material related to other matters for which the president is potentially under federal investigation as well, are those considered to be properly collected by the Justice Department? Do those have to be handed back? Is that sort of fair game if they come across things that's evidence of crimes for which evidence of crimes that weren't the crime that they went to that federal judge to get this warrant for today?
Yeah, it's a great question, and I apologize to you for making you ask me twice. I failed to answer it previously. So yes, if you are lawfully present in the home, and you are because a judge authorized the search warrant, and you're lawfully taking documents because it's listed in the search warrant as being potential evidence of the crime that you're investigating, then sure, it's all fair game. There are a number of doctrines that apply once you're lawfully in a home. Plain view would be one of them. Now, this is an outlandish example, but if they saw a sawed-off shotgun or meth on the kitchen table in distribution amounts, you can seize it because it's in plain view. But more reasonably and more rationally, if you find other documents that lead you to other investigations or avenues, and they're lawfully seized by lawfully present agents, yes, Rachel, fair game.
Chuck Rosenberg, former senior FBI official and Justice Department official. Chuck, thank you very much for your time this evening. Invaluable as always, but particularly tonight in this historic night. Thank you.
My pleasure.